ladies and gentlemen. I hope you can hear me.
Yes, yep, we can.
That's good. My name is Bill Firstberger. I don't know if you're waving to me or nothing.
Okay, all right, thanks.
And I'm American Community Manager. We have a very interesting program for you today. This is our first one, I think, of this year, is it, Ken?
It is.
So it's always a great program when we have this kind of expertise as a speaker. Now, before we start, I want to welcome everybody, which I think I just did. I'm reading this off this sheet here, so I don't know. And I want to introduce you to our senior staff, which I'll do in a minute. And I want to introduce you to our speaker, who's with Schild Law Group, Thomas Schild. Schild?
Shield.
I've only known him for 20 years. His name escapes me. This young man I've known him for a while too. Matter of fact, when I first got into this business many years ago, I joined CAI's board, the Chesapeake Chapter's board, and he was on the board. And I was always very much impressed with his level-headed legal involvement with the community association and with our clients. So I was really pleased to see him join up with such a prestigious law firm as Thomas Schild Group in Rockville. Lovely place, Rockville. And so he's going to be speaking to us today on the subject of community association governance, and that's a very good thing. I want to thank AMG, who is a sponsor this afternoon. He's down the hall now, but usually he's one of the community contractors that we work with. A lot of our clients work with, and he's helping us out today with some of the food costs and some of the other things that make this possible. And I want to tell you that we will be raffling off some stuff. More than one thing? More than one stuff? I think AMG is raffling something maybe, or we are definitely going to raffle off something today after the break at 5 o'clock. Correct? Okay. It's a good thing. I can tell you that. It's a surprise, but it's a good thing. You will be, we asked you if you could we have some questionnaire material. We asked if you would give that back to us and let us know. Bob, could you address the HVAC a little bit? Our landlord is a very bright guy, but he hasn't quite figured out how to deal with air conditioning. And I'd like to take this opportunity for you to meet some of you probably for the first time. Some of you work with some of these people for a while. We have some people who have been promoted in the last few months to take on more supervision responsibilities as I'm getting older and much more decrepit. First off, Frederick Jones. Frederick is our Assistant Vice President for Accounting. He's our go-to guy. He's got quite a team working with him that puts together the administrative or the accounting packages for the community boards each month. Charlene Pindell, who was actually here when I got here. She was over at one of our lovely communities in Cold Spring. And now she is our Vice President of Community Management. Charlene Pindell's in the back. Melody Flippo is our new regional manager, and she's handling areas around this area and into more southern Maryland. And Sherry Courtock, who is also here, has worked her way through our organization as a regional manager as well. And so Sherry's here, right here. Sherry's here bandaged up, which she usually does. We try not to let that Sherry wander around unsupervised. And Heather Griffin, where is Heather here? She's training, I think, somewhere. Heather is head of our administrative group and she's also working on our software updates. Bob Guerin, who's been with us now for a while, and I've known for 30 years, is our Vice President of Property Management. He's over there, and their offices are actually down the street, where we keep all the storage. And and we have a number of new people, and I hope you had an opportunity to meet some of the new folks who, when you came in today. And please make sure you talk to Charlene and Melody and Frederick and Sherry, who these people are and what they do and how they work with you. We have a number of people who are now working in our administrative and our community management group, as well as our property management group. We have expanded that as well. We're going to be doing some more with that this spring. Generally, I think that's about all I have to say. It really is with a great deal of pleasure that I tell you that this young man, Scott, I'm going to read now, they told me his mother wrote this one. It's not very wordy. He has more than 20 years legal experience representing condominiums, housing co-ops, homeowner associations in Maryland and D.C. He has worked in community management boards and their managers in Montgomery, Prince George's, Howard, I don't have to read it, all of the counties that we have, and the District of Columbia. He's an active member of the Community Association Institute, which I won't hold against him. Scott served on the board of directors for CAI, Chesapeake region for 6 years, and as chapter's president in 2009. He also regularly presents CAI education and training programs and association. I have a great deal of respect for this young man. He's always done a great job for our clients. We're very lucky to have him today. I'd like to introduce Scott J. Silverman.
Thank you all so much, and thank you to Mel and Charlene and Tony in particular for inviting me out today and giving me the opportunity to visit with you all and hopefully give you enough good information that you feel like you didn't waste your time coming, and but not too much so that if you ever get into trouble, you decide you can't live without me and you gotta call me. So I've been asked to do a number of things today. First, before I get started, I'd just like to know how many board members, homeowners do we have in the audience? Oh, quite a few. That's great. Okay.
That's who we invited.
That's good. I didn't know how many were managers versus how many were. You all have a big staff, so that's great. That's wonderful. I'm glad to hear it. Any cooperative people here? One co-op man. All right. Well, I'll try and throw in the co-op information wherever I can for you. All right. Well, that's good to know. I have been asked to present first and foremost the legislative update. Let you know what's been going on in Annapolis and what happened last year, what they're up to this year, and things to kind of keep an eye out for. So let's see. Oh, there we go. Oh, sorry. That's the out. There we go. Maryland legislative update, and we will start with. All right, that's just a little something to tell you about the Maryland LAC. And the LAC, just to give you a quick synopsis, is a group of people that belong to the Community Associations Institute, which is a nationwide organization dedicated to furthering the goals and objectives of community associations and their members. It's joined by board members, managers, lawyers, accountants, and all sorts of other vendors. And the LAC's job is to monitor the legislation that's coming out of every state. And every state has a chapter that's commissioned by the national organization. And their job is to keep an eye on what's going on in Maryland, in Annapolis, and DC has its own chapter as well. All right. Hope you like my transitions here. This is my first PowerPoint where I had to put the jazz in myself. All right. First things first. Last year, there was a bill passed, 1192, which is House Bill 1192, Senate Bill 816, which is now law, which basically codified the amount of money that management companies can now charge on behalf of community associations for resale packages. Okay, and it also changed what needs to be in the resale package. So right now, a homeowner can be charged up to $250 for a resale certificate if they want it on a rush basis, and a lot of realtors say, yes, I have to have it on a rush basis, I've got to have it within 7 days. It's $100 more for a 7-day delivery, $50 more for between 8 and 14-day delivery. If they need to do an inspection of the unit or the lot, they can charge $100. And the law says that every 2 years, the General Assembly will reevaluate these fees according to the Consumer Price Index and bump them up if the market demands that happen. There we go. All right. In addition, the resale certificate must now include a copy of the current reserve study for the condominium or the homeowners association, how much the reserve fund balances are in total, and violations of which the association has actual notice. And by violations I say, for example, if the county has cited the association for a stormwater management pond problem or a building code violation or something like that, and the community has actual knowledge of it, they have to put it in the resale certificate. With regard to litigation, what litigation means is those unsatisfied judgments. In other words, the association has now had a judgment entered against it, hasn't paid it, has to be disclosed, and any lawsuits to which the association is a party, that means active lawsuits, now pending, except for collections matters. So they don't have to disclose ordinary legal actions to collect assessment, past due assessments. Those are out of bounds.
What about for violations, like the condition of the home?
Yes, that is already in the statute. And these are changes. So already in the statute from before, if there is a violation pertaining to the specific unit or lot, yes, that must be disclosed, which goes hand in hand with the inspection as well.
Right.
Would that also include a lien if we filed a lien to our attorney against the homeowner? Would that be?
No, that wouldn't be required because the liens are matters of public record, and those are picked up independently in the title search. And they can't convey clear title and get title insurance. The buyer can't get title insurance unless the lien is satisfied. So those would have to be taken care of. Yes?
Can we get copies of these slides, or do we have them already?
You do not have them already, but if you would like to give me your contact information, I would be happy to send you a copy of the PowerPoint. Yes?
Maybe they could just post them on the website, so you don't have to ask individually.
I could certainly do that. I could certainly share that with them as well. They already have a copy of it, so if they'd like to post it on the website, that would be fine with me. Okay. All right, next one. Tax sales. All right. Here's the deal. Common areas are not subject to real estate tax, but they are subject now to what they call the rain tax. Okay? Yes, still. So what's been happening is that there have been common area properties that many associations don't even know they're supposed to own that have been going to tax sale because the contact information for the property itself is not up to date. Either the developer never conveyed it, or they never or nobody ever changed the information on the tax bill or what have you. So they've been going to tax sale. So what this does is it requires the tax sale purchaser to give notice to the association if there's a recorded lien against the property to be sold. That one, the first one, applies to tax sales of individual units and not to the common area. And then the bottom one clarifies that the tax sale purchaser will owe assessments This bill applies, I apologize, applies to individual units. There's another bill coming that applies to the common area. So with regard to individual units, it clarifies, and this is already the law in Maryland, in a foreclosure situation, as soon as the hammer falls at the foreclosure sale, whoever buys the property is obligated for assessments from that point forward. In a tax sale, the timing is different. You have the tax sale, and the tax sale purchaser has up to 2 years to file suit to do what they call foreclose the right of redemption, which means to terminate the prior owner's interest in the property and to take it over. When the court enters judgment in that lawsuit, that's the cutoff date. So there can be a long lag period during which nobody's paying assessments. Technically, the prior owner is still responsible, but unfortunately, the association may never be able to collect those because they usually, if they're in tax sale, they're also already delinquent and they already owe you money. So it just means you have more money that you can't collect. All right, next one, consumer debt collection. You may or may not be aware that the purchase of debt is a big business. During the years of the Obama administration, there was a big surge to regulate commercial debt collectors. And part and parcel of that, coming out of that effort, is this law, which says that if you buy debt, in other words, if the association were to sell its debt to a third party, and there are companies out there that will buy it from you, in order for that party to proceed to collect against the delinquent owners, there are certain procedural steps they have to follow in order to file suit. And it also, most importantly, says that anybody who is collecting any debt, this doesn't just apply to debt collectors, but to everybody, if your debt is beyond the statute of limitations, which is generally speaking 3 years, you cannot file suit. It used to be in Maryland that the statute of limitations was what they called an affirmative defense, which means you file suit and it's up to the defendant to say, well, wait a second, this is time barred, you can't collect this. Well, now the burden is switched to the plaintiff, the association, and if they know that their debt is too old, it can't be collected, it's out of bounds. So it shifts the burden of proof a little bit and definitely in favor of the consumer. Yes, ma'am.
How does that affect us when someone hasn't paid their monthly fees in a number of years?
Well, it depends upon what when your documents, or how your documents were executed. There's a case in Maryland called Columbia Association versus Petit, which says that if your documents were signed what they call under seal, and I'd have to look at them to tell you if they were, then you have 12 years to file a lawsuit. There's a 12-year statute of limitations. Otherwise, you're governed by the general 3-year statute of limitations, which governs contract claims. And because your documents are considered to be a contract between the association and the owner, then what governs contracts also governs you. So if your debt is more than 3 years old, then you're not going to be able to collect it.
Some parts of it.
So you got to be really careful to make sure that these past due accounts are being turned over for collection in a timely and regular manner. Otherwise, the association could find itself having to write things off because it can no longer collect them. Did that answer your question?
We have had attorneys working on it all this time.
Okay.
But has success, really. Just
Okay.
once in a while he
Well,
pays something.
that's what we can talk about that
Oh, that's what
offline
makes
if you want, but not having success is different than not doing anything at all.
Okay, yeah, we have it, right? I'm trying to determine how much you might be able to collect versus how much you might not be able to.
I really have to, first I'd have to look at your documents and then I'd have to look at the individual account statement to be able to tell you where you are, but I'd be happy to do that if you like. Offline. Yes?
You get a judgment, you get a judgment for the court.
Judgment, once the judgment is entered in your favor, it's good for 12 years and it can be renewed. So the statute of limitations is not an issue once the judgment is entered. That's a preliminary defense. So if it's not addressed preliminarily by the court, then it's deemed waived. Yes, ma'am.
Does a promissory note affect that at all? Does that explain?
Potentially, yes, it potentially does, because what can happen is you can have somebody, an owner, enter into a promissory note to reaffirm liability for a debt that might otherwise be time barred, and the note renews, starts the clock again. So it becomes then 3 years from a breach of the note, as opposed to a breach under the original documents. All right. Okay. This next one, duty of care. In Maryland case law, for years, and this is where associations and corporate law kind of blend into each other. For years, there have been many cases that have interpreted what is the appropriate standard of care for a director, okay? And various courts in various counties have come to their own conclusions about what level of reasonableness is required, what level of scrutiny is required. And in the case of community associations, it's particularly tricky because although you are quote-unquote corporate officers for all intents and purposes, you're also lay people. And you're not expected to be landscapers, engineers, et cetera, et cetera. So it's been difficult to nail down exactly what the standard of care is for you and what, as board members, you can be held liable for. Well, now the legislature has solved that problem. They have said that the duty of care is good faith, reasonably believed to be in the interest of the corporation, exercised with the care of a reasonably prudent director. Now, this was adopted last year. There are no cases on this. You have a lot of very soft terms in there that are open to some interpretation. But what is good about this is it takes out of play what we used to call the breach of fiduciary duty claim. That's completely now out the window. You can't sue for that anymore. You can only sue for this. So now what this means under specific sets of circumstances will vary. But this is the new standard. What's important to understand, though, and this is critical, is that decisions not to take action are also subject to review. Okay? So if the board decides not to enforce in a specific situation, that decision can also be reviewed, and it could constitute an act. Okay, now, what makes it even a little more complicated is that there's this thing out there called the business judgment rule. This statute does not get rid of the business judgment rule. All right? The business judgment rule operates as the first line of defense for the association. So and what that says is, as long as there's no fraud or self-dealing, then you can't go behind the board and look and try and make the decision. The court cannot make the decision in lieu of what the board's decision was. In other words, it cannot make the decision what they call de novo, as though they were sitting as the board. So you don't necessarily get to this standard unless the plaintiff, the party challenging the action, has already gotten over the hurdle that there's some sort of fraud or self-dealing that has gone on, because that will still protect, the business judgment rule will still protect the association. Sorry, I didn't get that. There we go. All right. Another key element is the board now may be sued both in the name of the corporation and also by an individual owner. Okay? That's under the statute. Under common law, that was pretty much true already. You already had individual owners suing board members. And then, most importantly, a director or officer acting in accordance with the statutory duty of care is immune from personal liability, which means if you are found to be in compliance with that earlier duty of care we looked at before, then your personal assets cannot be reached. Before y'all get really scared, don't forget there's insurance, okay? It's the blanket that protects everybody. You have directors and officers liability insurance, and you also have fidelity bonding, which protects you in the event that something goes wrong. Okay, you're not expected to be perfect. You can exercise business judgment and you can exercise reasonably prudent care and still get it wrong. But you would still be protected. And your insurance company, in almost every normal circumstance, will step up and defend you. Now, where they're not going to defend you, and we'll get to this later, is in very specific instances like intentional conduct or with regard to discrimination. They're excluding discrimination claims, and we'll get to that later when we get to the federal legislation, but that's something to bear in mind. So, there. All right. That's what passed last year. Now, one of the functions, just to tell you, one of the functions of the Maryland LAC is not just to promote the bills that they want, but to stop stupid legislation from going through. Okay? So these bills, either because we opposed them or because they just died on their own accord, did not go through. Some of them have come back this year. All right? There's one that says you got to take your hang tag off while you drive. It's kind of like a common sense one, but for whatever reason, that was not yet in Maryland law. You could drive around with your hang tag hanging off your rearview mirror. If this passes this year, you won't be able to do that. The next one, associations required to permit installation of vehicle recharging stations on common area. We oppose that because it's got all sorts of problems. How do you get the power there? Who owns the common area? Who owns the equipment after it's installed? Number of problems the statute didn't even come close to dealing with. The next one's related to that, towing from a electric vehicle station parking space. The next one, a common ownership community registry. That one is back this year. It's being debated again this year. What they want to do is create a statewide registry of community associations so they know where all y'all are. My suspicion is that working under this is some sort of trying to keep track of the voters thing, but that's my personal opinion. They're not saying that. There was some legislation that changed the timing on warranty claims that did not go through. Well, let's see.
So your title is saying these are probably not going to be passed?
Some of them are back, as we'll see. Whether they'll go through again, I don't know, but we're going to encounter the same kind of situation we encountered last year. Yes, ma'am.
I had understood that the one about the electric car charges might be coming back.
It is back.
It is back.
It is back.
Okay.
Yeah, we'll get you. I'll get to that. I'm getting there. Okay, foreclosed property registry. They want, and this is actually a good thing, but the problem with that legislation was just the logistics of how they were going to set it up and how it was going to be funded. But I actually favor creating a foreclosed property registry so we all know where the foreclosed properties are and how to get a hold of people that are responsible for them. If any of you have had foreclosed properties that have had pipe breaks, you know what I'm talking about. You know, it's very important to know that. The polybutylene pipe thing is interesting. You may recall years ago there was a polybutylene pipe replacement program where apparently they concluded that some of the pipes were not replaced. Some of the branch line piping was not replaced. So the WSSC has encountered some of this recently, and they want another program. They want the state to fund another program that they will administer to allow you to replace any polybutylene piping that you haven't already replaced. Let's see. So that one is also back this year.
Is that, you mean on common property?
Yes.
Oh, okay.
Yes. But I believe, well, it relates to community association with respect to common property.
Right.
But I believe that the replacement program is going to be available to everybody through the WSSC,
okay.
including single family homeowners who are non-association related. Requiring notification to the property manager prior to terminating public utility service. That's probably a really good thing. That one I think is being refiled, but I haven't seen it yet. They're not done. Sales use tax exemption for energy. That relates more to solar energy and other alternative forms of energy. Okay.
1080 is, what's the percentage they want to reduce it to?
They wanted to reduce it to 55%, but the way they worded it was originally was like 55% of those present. if a quorum is present, and the way the math worked out is, in smaller associations, you could have like 3 people amending the documents, which won't fly, in our opinion. So we kind of alerted them to that and said, your wording is a little funky and you might want to change it. Reducing it to 55% of the overall isn't necessarily a terrible thing, but bear in mind that doing that might also trigger lender approval requirements, so we may not be able to get that. Let's see. Sorry.
Can I have another question?
Yes.
If they were to change to pass that HB 1080, and the bylaws of your association say otherwise, does this just automatically overrule that, or do you have to vote on your bylaws to change what's in them, or what?
No, what it'll do is, if they pass the legislation, it will override the 66 2/3 that's already there.
Okay.
It's unclear, there's a debate right now as to whether they're gonna make it, unless your bylaws state otherwise, or they're gonna make it a wholesale override, to push everybody's down to 55%. Let's see. Flip. Make sure I get everybody. Okay, last couple. The last couple that did not go through: responsibility for maintenance of residential property and registration requirement. I'm not even sure what this one was supposed to accomplish. It was kind of vague. And the notice of postponement or cancellation of foreclosure sale, that's a really good one. We actually would want that one, and I believe that one is also coming back this year, where the foreclosure lender, the foreclosing lender, is required to tell us not just that there's going to be a sale, which is already required by law in many different places, but also if they postpone the sale or they cancel it, which kind of relieves us of the burden of having to chase them down. Because right now, as many of you know, you'll get the initial notice, and then whoever your attorney is or management company that's monitoring the account has to then call the foreclosure attorney day after day to try and figure out what happened, and that's now going to be the burden on the lender. All right. There we go. Okay. All right. Back this year. All right. Here we go. So you see, the rearview mirror one is back. Notification of cancellation of a foreclosure sale. Postponement cancellation, that one's back. Last one, last year, remember I talked about the resale inspection fee was $100. They forgot to put that in the Homeowners Association Act, so they're proposing to put that in the HOA Act this year so that there's parity between the condos and the HOAs, so they can charge the same thing. All right. Net HB 36, big one on the electric vehicles, how to mark the pavement and imposing a civil penalty for having the space occupied and having to be towed or whatever. The last one, the registry is back. They want to collect a $3 per door annual fee and a $50 fine on the association for failure to register it. It's interesting. It's unclear what they're going to do with this registry once they have it, because if you may be aware, in Montgomery County and now in Prince George's County, they have independent commissions that deal with community association issues, and they also have registries and fees. This statute would exempt any association that's already registered at the county level and is already paying, so that you don't have a multiple level requirement. But at the county level, they offer ADR, alternative dispute resolution, and they offer, Montgomery County does hearings on actual disputes. it's not clear that the state is ever going to get to that point. So we can't tell exactly what the state's going to do with this information once it gets all these registrations, which is why I think it's just to keep track of voters, but that's neither here nor there. Yes, sir.
Is there a requirement that you have to have an electric plugging parking spot in your condominium or co-op?
No, it would be by request. So in other words, it's saying that you can provide it at the homeowner's request, and then the homeowner will be responsible for creating the space and funding the equipment, if they want the equipment there, for their exclusive use. If the association wants it there for common use, then it would be the association's responsibility to finance the equipment. Yes, sir.
We have a restriction on smoking around. There's no smoking.
You have a no smoking covenant? Okay.
So when does that come from?
Hang on. We're getting to that. Right now, there is the ability for an association to prohibit smoking in the common elements and also in individual units within a condominium if it can get it passed. Okay? The law, the statutes are silent on this. This statute would say that the association could affirmatively restrict these. I'm not sure what more it does that you can't already do, and the statute doesn't make it any easier to get these restrictions passed, because you still have to get over your initial hurdle to get your documents amended. In other words, it doesn't automatically amend your documents, it just gives you the authority to amend them, which I believe you already have. Yes?
So I did pass 75%, there's no smoking in the whole building.
Okay, well that's good. I mean, you're somewhat unusual, because not every, I've had a number of condominiums that have tried to control smoking, regulate smoking to different degrees. Some have gone just to the general common elements, some have gone up to include also limited common elements like balconies and patios, and some have gone the whole board and they've tried to encompass the individual units, and some have been successful and some have not. So it really depends upon your population as to whether you can get a smoking restriction through, but there is certainly the support, obviously, out there in the scientific community to make a regulation like that reasonable. In other words, if it were challenged on reasonableness grounds, in my opinion, the association would absolutely prevail, because it has an interest in protecting the health of everyone, and as long as you're not preventing somebody, from there's no right to smoke. Nobody has a legal right to smoke. So the problem that you have is usually with your own membership and ownership, and you have this fight between people that want to regulate versus the my home's my castle people. So, and you have to negotiate that.
Well,
Yes, sir.
You could take it to the nth degree if you can prevent people from smoking in their unit, then you could then prevent them from drinking in their unit, or anything else in their unit.
The question is, what are the effects of drinking that you're trying to diminish? In other words, if you go at it from people who are drunk are loud and unruly, that's difficult, because that's not always true. Whereas, bear me out, the smoke will always transmit from one place to another. And the rationale behind regulating smoking is that when you're in a multifamily building, you can't control where the smoke goes. So if you have any shared common ventilation piping, or you have you're smoking on the balcony and it's going from your unit to the next unit, to the unit below, or the unit above, that's in my opinion, is much more reasonable for the association to want to control that, because the transmission of the smoke and the odor is absolutely certain. I mean, it's virtually impossible to contain it. In a house, obviously, that's a little bit different scenario. Yes?
If you have no law in the community regarding this smoking, is it permissible for a landlord to forbid their tenants to smoke?
Yes. Absolutely. And I actually, it's interesting, I had that situation in a townhouse association up in Harford County, where the landlord had prohibited smoking, which forced the tenants to smoke on the outside rear deck. And then that unit was one in from the end unit. The owner of the end unit, who was an owner-occupied unit, was a police officer. And he complained that the outside smoking made it impossible for him to allow his children to play outdoors, rendering his rear yard basically unusable. And there was a lot of pressure on the association to ban smoking on the rear decks because they can't control where the smoke goes. So as it happens in that case, our opinion was that the association could potentially be required to enact such a rule to protect those owners. Fortunately, the tenants moved and the issue went away. Yes.
Or could the landlord prevent the tenants from smoking anywhere on the property?
They could. Yeah, I mean, as long as it's within the bounds of the property that the landlord strictly controls, then yes, they can put it in the lease, and absolutely, the landlord can do that, even if the association has not prohibited it. All right, next one. Let's see. The big one at the top. All right. Right now, there is a case pending before the Maryland Court of Appeals called Rose versus Elverton Town Condominium. It is a condominium association located in Anne Arundel County. And what happened there was the Roses, who were delinquent, were denied the ability to park and to use the pool by rule. The association the condo adopted a rule and said, you cannot park here and you cannot use the pool. Okay? The Roses challenged that in court and said there's a provision of the Condominium Act which says that you cannot, by rule, impair my easement and ownership in common elements. The circuit court said that the Roses were right. And that rulemaking power in and of itself, just general rulemaking power, which you have in your documents and under section 11109 of the Condominium Act, was not sufficient as a basis of authority to ban these people from using the common elements. The Maryland Court of Special Appeals, which is Maryland's intermediate court, affirmed the circuit court and said that the Roses were also right. The association appealed again. And at the beginning of this year, there were oral arguments in the Court of Appeals, which is Maryland's highest appellate court, basically asking the court to give an opinion as to whether the general rulemaking authority can be used for this purpose. And we are waiting for that opinion. That opinion will dictate whether rules of that nature, based upon a condominium's general rulemaking authority, will stand up. Now, it's been my opinion that if your governing documents include specific authority in your declaration or your bylaws, which explicitly say you have the right to deny parking in the event of a breach of these documents, which would include delinquency or other architectural or rule violation, that is explicit and specific enough authority, and it goes beyond your general rulemaking authority. And the appellate opinion that has already come out suggests that that is also true. What we're trying to do is get clarity from the Court of Appeals on the general rulemaking authority, and hopefully we'll get it soon. In the General Assembly, however, somebody in the General Assembly tried to leapfrog the Court of Appeals and legislate this right now. And the opposition is, well, let's wait and see what the Court of Appeals says first, and then if we don't like their answer, then we'll legislate around it like we did with the pit bulls. You may recall that years ago they said pit bulls were basically inherently defective and dangerous, and then the legislature came and said that they're not, and we're going back to the prior rules. So we'll see. So the answer is, when Elverton comes out, it's going to be big, big, big news. And we actually have I have for you on the table, in addition to our newsletter, an article that my partner wrote about that case that was just published today in the CAI Chesapeake Chapter Beacon, which is their quarterly newsletter about that same subject. Yeah,
that's the issue we're having at ours.
Yes,
that's the issue we're having at ours, because the delinquency is so severe that they still have the authority to still use their parking space. So what's happening now is that because you got so many people with cars, that because our laws does not govern saying that you cannot have that space because you're delinquent. So what I need to know is how can we go about getting a lawyer or somebody to change our rules? That's the issue we have.
Well, first thing you have to do is call me to make me your lawyer.
Okay. Who needs your
And
car?
then we'll talk about
Oh, yeah.
it. Got it right here, and then we'll talk about it.
Because what happened is because in Aberdeenshire, you have one homeowner who's renting out, and you have 5 cars because they don't own the property. So that means that you're taking up 3 spaces that are.
Yeah, that goes beyond this problem. That goes to a parking control problem, and I've got a bunch of ideas we can talk about how to fix it.
Good.
So grab my card and call me and we'll talk about it. Yes, ma'am.
Is there anything related to HOAs in that issue? It says condominiums, so is that
Right,
specific to condo
because,
associations?
yes, and the reason is that the case that's on appeal right now stems from the general rulemaking power that's in the Condo Act. The HOA Act doesn't have general rulemaking power. It doesn't have the equivalent of 11.111, which controls how you make rules, or 11.113, how you enforce them. All your rulemaking is in your governing documents.
Right.
So what I would say to you is, if your governing documents include a general rulemaking power, you have the power to adopt, promulgate and adopt rules and regulations. That's not going to be enough. It's got to specifically go to say, have the power to suspend for violation.
Yes.
If it has that language, in my opinion, it will hold up under the current decisions.
That's what we need.
If Elverton goes the way we want, general rulemaking power might be enough as well, which would be great. I don't know how it's going to go, but we'll see. Other questions?
When is that decision going to come down, do you think?
Unfortunately, the Court of Appeals has no timeline on when it must decide cases. I had a case in the Court of Special Appeals that I waited for almost 2 years for. However, the Court of Appeals did agree to accept these cases, like the Supreme Court in this case went to it on what they call a writ of certiorari, which means that they had to ask permission for them to take it. So since they wanted it, the expectation is that they'll issue the opinion relatively quickly. I mean, it has only been a couple months. So hopefully, I'm hoping by the summer, we'll have an answer or prior to even, because that will dovetail nicely for when pool pass discussion comes up, which is part and parcel of this same issue.
So if an association does a simple resolution saying if you are delinquent more than, say, 60 days, you're not permitted to use the pool.
That's not enough. Unless there's authority that says exactly that in your bylaws, or preferably declaration. I'm hoping that they don't come and say it has to be the declaration, because that makes it much more difficult to get there, because as you know, the declaration thresholds are much higher. Yes, sir.
Let's say you have a condominium where each unit has 2 parking spaces, or you have 2 gated community where you have 2 separate entrances, and they still have the privilege of using, a parking space and a gate.
Right.
Not the most convenient one. Would that example fall into that same situation?
Potentially, yes. It really depends. I mean, I've got communities now that say they're not, the rationale is, like, for example, they'll disable the key fob, but you still are able to get into the building. And what they say is you're removing the convenience but not the access. That's okay. Or if you say, we're gonna, paint over your reserved parking space, so you don't have a dedicated space, but you theoretically have the ability to still park, theoretically, because of course it's always subject to availability. Then yeah, it might work. But it depends. It's really a case-by-case thing. It's something that, in light of where we are in the law and not having certainty on this particular issue, my recommendation would be call me and ask me, can we do this? Yes, sir.
Somebody who can't pay their fee, pay a lawyer.
That's an excellent question. And I'll give you the answer. There are lawyers out there who are looking to get community associations, their management companies, and their lawyers for what they call violations of the Fair Debt Collection Practices Act. And this is kind of an outgrowth of that cottage industry litigation, because the attorneys that handled this case on appeal were the same ones that are chasing all of us for violations of the FDCPA. They're making a career out of it. So the answer is that they take it because they want to, it's either on a contingency or they're making they want to create what they call, they want to create a class action out of it, where they can make a lot more money. Next one real quick, because I know we're taking up a lot of time. I want to stay on schedule. Reserve study every 5 years required, and reserve funding disclosed in the resale certificates. That one's back. Next one, one I talked about before, dropping the percentage to require a bylaw amendment from 6 2/3 to 55%. That one we're supporting with amendments to make sure that we're talking about 55% of the whole and not just 55% of those present. Yes, sir.
Do the reserve study bill and the reduce the percentage bill at the bottom apply to condominiums only, or do they also apply to homeowners associations?
Both. No. Not to co-ops.
They apply to both.
I'm sorry?
They apply to both.
They will apply to both, yeah. Last is the community manager registry, and what they're trying to do. One of these bills has been withdrawn, and the other one, hang on, I got a current status for you. The other one is scheduled for hearing, well, was scheduled for hearing on March 1st, but they haven't reported back on it yet. But these, this particular one wants to create a statewide registry of community association managers and basically make it like the real estate commission. And
is that 11,
administrative
what number
framework.
is that?
I will tell you, hang on. 1192, 1193 got pulled.
1193 was Elliot Holmes, who,
right.
I don't know what he was trying to do. He said he was putting it in to pull it and send it to summer study. And then Derek Davis, who's the chairperson of that committee, made a commitment to CAI that he was going to pass the bill. This is the same bill that we looked at since 2010.
Yeah.
That I take great pleasure in killing every year. I'm not involved this year.
Right.
They are. It's a very expensive bill. I would imagine it's going to double the cost of community management fees. It's going to, even those of you, and we have a lot of communities, several, almost 50 now, that are self-managed. You will have to hire a licensed community manager, even though you self-manage. I mean, what this is there's a lot of things in there that are good, a lot of things that we did support, but what it primarily is selling designations for CAI. And you're going to have to only deal with people who have these designations for CAI. It's unusual that they even put it in the bill. It's in the language of the bill itself. That you have to have, to manage a community, you have to have a designation from CAI. So I mean, it's an expensive bill. They won't do any more than what's being done now. There's a lot of other ways to do it. We offer them language that would license the management company, or the management company is responsible for the actions of their employees, which I sort of thought we were anyway. And there was questions about certain language in contracts that should be standardized so people cannot be taken advantage of by unscrupulous management companies. All of that doesn't matter because what they're all about is legislating designations. The problem is that there are only 80 community management companies in the state of Maryland, according to CAI. And there are 1,100 community managers. So if you're selling designations, who do you want to sell it to? You want to sell it to the 1,100 community managers. And that's what this is all about.
What bill number is that?
That's 1192.
1192?
Yes.
1193 was identical.
Yeah,
There was also
1193
one of
was
the-
identical, and that one got pulled.
Pulled, that was Delegate Holmes' bill. And then
Right.
530, I think it was a Senate bill.
Yeah.
And that
That
didn't
got
get pulled, but that's fine. But
Yeah.
all the same bills, and they even say in the notes that this is the same bill that that was defeated in 2013, 14, and 15.
There's also, just to give you a quick update, there's a bill that, like with clotheslines, they want to invalidate covenants that would prohibit backyard gardens. So people would be able to have backyard gardens. That one's already received an unfavorable report out of committee. And a couple other bills. CAI has opposed one bill that makes it more difficult to collect money. Once you obtain a judgment, the bill would require the court to make very difficult determinations with regard to what they call body attachments. What that means is if you're trying to collect on a judgment and you ask somebody to come into the court for what they call an oral exam, in other words, they answer questions about their assets and they fail to show, the next step is what they call a show cause hearing. And you serve them with the show cause order. If they don't come for that, then the court can issue a body attachment, which means they can actually be arrested and brought to the court. And I've actually had this happen a couple times in my career where they called me and said, "We've got this person here, come do your thing." And you have to go to the courthouse right there, and they swear them and do the oral exam right there. Now, they don't arrest them in reality for this reason. They happen to get them for something else. And when they pull them up in the system, they see there's a body attachment, so they hold them for that too. So yeah, I mean, but we've opposed that because it would make it too difficult to get these things. And then, let's see, what else, just to let you know, any other interesting, everything else that I told you that was pending in the legislature is right now either in the House or the Senate. Some of them have passed one chamber and have now gone to the other, some are waiting hearings. There is a website, which I can tell you where it is, where you can plug in, if you don't already know, plug in the actual bill number and it'll tell you everything about it. It'll show you the fiscal notes, in other words, how much they think it will cost, the text of the bill, and where it is and what's happening. And it explains to you how the bill becomes a law, which is a somewhat convoluted process in Maryland. Yes.
Is each bill clear as to whether there's a grandfathering clause in there? In other
For
words,
which one?
I mean, is there a general rule that the bills must state whether things can be grandfathered?
No,
pre-existing?
there isn't. It varies. There are some that will say effective this date and its perspective. And then there are some that will just override the whatever has occurred before. So, like for giving an example, years ago there was a change to the Condo Act provisions on insurance, and those they wiped out whatever had occurred before. So as of that point, that's it. That was the law. All right, federal, real quick. Here we go. Federal level. Now, nobody knows really what's going to happen now in the new administration. The expectation is they're going to roll back a lot of regulations. The regulations that matter most, and I'll get to those in a minute, to us are the HUD regulations. And FHA, I don't know whether they are going, there's one that's very important that may or may not get rolled back once Dr. Carson figures out what it is and what it does. But they did pass, back last July, the Housing Opportunity Through Modernization Act, which basically tells HUD that they want condos to be certified more easily for FHA loans. And it reduces the owner occupancy ratio from 50 to 35%. And it encourages more mixed use approvals. That's important. The Amateur Radio Parity Act, sort of like the Telecommunications Act years ago on satellite dishes. Now they're talking about ham radios. They're saying that this one passed the House last year, but not the Senate. It's been refiled this year. And the association will be able to regulate the antennas the ham radio antennas in pretty much the same way they can already regulate satellite dishes. There are certain things you can do up to a certain diameter or dimension, but then beyond that, it's, fair game for the association. HUD fair housing rule. All right, here's the big one. The hostile housing environment. There was a rule passed last fall in the waning days of the Obama administration, which says that the association can be held responsible for creating what they call a hostile housing environment, or permitting it to exist. All right? And in other words, you could be responsible for the conduct of third parties, i.e. other owners toward other owners, of which you know or should know. Now, what that means, nobody knows, because there hasn't been enforcement of this rule yet. So I don't know how this is going to play out. But if it remains on the books, it is potentially problematic for associations, because now you could be held responsible for this owner-to-owner stuff that goes on that we all know about, and we usually tell the boards to ignore and make the owners settle it between themselves. But if you have an owner that is saying that my neighbor is acting in a discriminatory manner to me that is preventing me from enjoying what they call equal housing opportunity, in other words, the use and enjoyment of my dwelling, and I complain to the board about it and you don't do anything about it, you can be responsible for creating a hostile housing environment, which without guidance I can only interpret as being equivalent to a hostile workplace. We all know what the legislation and litigation on that has been, hostile workplace. So it's unclear whether this rule will now fall, to the axe of the new HUD or not, because we don't know whether the new HUD, the people in charge, even are aware that it exists. So it's hard to say. But why it's very problematic for associations is most of your insurance policies exclude discrimination. So if you get sued for housing discrimination, you may not be covered under your D&O policies. So it is a potentially very dangerous weapon in the hands of an owner with an axe to grind and an attorney that they might find that is looking for a quick buck. So it is very much a concern of ours. Yes, ma'am.
If you have an owner that has an unruly tenant in a condo unit, could you be held for that?
Potentially.
Because, we just ended a situation like
Well,
that. So
potentially,
fortunately
because you're being held responsible for the acts of third parties, of which you may or have reason to know, and third party could include a tenant. It's very open-ended.
But we don't have
and
control.
hugely problematic. And honestly, they sort of slipped this one under the radar. Nobody really knew when it was proposed what it was intending. For whatever reason, it got through the comment period, and nobody stood up and yelled and screamed. But I don't know if it was because they saw, housing discrimination. Nobody wanted to take a position where they could be characterized as being in favor of discrimination, or what have you. But for an association, it creates massive issues, because what is knowledge? Does that mean if a single board member is aware of the problem, the entire board knows? That might not be true.
So you don't have control.
Correct. And in many cases, you can't do anything about it.
That's one, yeah.
You can't do anything about it. In other words, and I think that's the problem. And I know that on a national level, CAI has been trying to work with HUD to make them aware of this and to try to pare this back. Next one, let's see, total number of FHA units, owner occupancy. These are proposed rules. Don't know if they're going to go through or not, but it would change. Right now, they're to be certified as FHA. They look at how many other FHA loans are in the project, what the level of owner occupancy is, and things like how much commercial space there is, what reserves you have. So what they're talking about is allowing the HUD regulators to look at these things on a sliding scale. In other words, no criteria would necessarily be fixed. If you fall short in one but you exceed in another, they can look at it in a more variable way. And then the last one would be a great thing if they passed, is to extend it from 2 years to 3 years. Right now, it's only on a 2-year cycle, and then you have to re-up. So this would extend it to a 3-year cycle. There. Okay, local, very quickly, and then we'll take a break. 2 things to be aware of. Prince George's County, in 2015, they established the Community Commission on Common Ownership Communities. They already had one for years and years and years in Montgomery County. Now Prince George's County joined the bandwagon. They have an annual fee, but it's not a per door fee. So there's a real funding issue that's going on here, but what they have now is mandatory dispute resolution if the owner of the association requests it. The legislation has big problems, and we're trying to work with the county council to get it revised because there's a couple provisions that are very open-ended, such as when can the association terminate the commission process and go to court if it determines that it's not working. But right now, as of the beginning of January, I went to an information session in PG County on the commission, and they had only one case that was potential for ADR, but it was withdrawn, and the parties decided to go to court instead. So I don't know how many cases they have right now, and where they are. As of January, not all of the commissioners have been seated yet. I'm not sure whether they've all been approved by the council or not. In Montgomery County, the commission has moved from the Department of Consumer Affairs over to Housing and Community Development. They're in new quarters. They've got more money, and the good thing in Montgomery County, for those of you that have any interaction there, is it used to be that jurisdiction over the case was decided way later in the process. Now they've moved it up to the beginning. So the commission actually decides right up front whether they have any jurisdiction, and if they don't, they kick it right away. It used to be we had to go down several steps down the road before they made that determination, and it was just costing money for the association. Last thing, Montgomery County, there's proposed B&B legislation. B&Bs are a big thing now. Everybody wants B&Bs to make money. Right now, the legislation, if passed, would permit a B&B wherever residential development is permitted. However, would restrict it to 14 days per month or 90 days a year. No parties or unregistered visitors on the properties. Has to be the primary residence. Proof of notice to neighbors, adjoining neighbors, and would require a transient lodging license.
So that's actually been introduced?
It's been introduced, but it is on hold right now. All right. It is, you guys want to take a break now? Okay. Legislative update took longer than I thought. I apologize. There was a lot there. And I will, let's take a break, and then we can reassemble and go through the meeting. Okay. Getting now to making and enforcing rules and regulations, exercising architectural control. I put these 2 things together because although they're somewhat different, the principles are shared. Architectural control, as you know, is a covenant. It appears in your declaration or in a condo, in your bylaws usually. And what it says is, shall not post, paste, hitch, screw, nail, whatever, without prior approval. Okay, and there's a couple exceptions to that. Satellite dishes, generally can't say no to those. Can't say no to clotheslines anymore. Can't say no to flags anymore. And solar panels. Okay, so we already know that there's some exceptions. But in general, architectural, hang on, I'll get you.
This is HOA and condo.
Both HOA and condo. Now, obviously, condo's a little bit different because you have limited areas that are subject to architectural control, much smaller areas. Much more of an issue in townhouse and single-family HOAs because there's a lot more to alter there. And you have yards, usually, as well. So the big thing to remember is to start at the beginning. With regard to rulemaking, the question is, in your documents, is this something you can regulate? Do you have the authority to do so? Like we were talking about before, are there specific provisions there? Can I promulgate and adopt rules regarding parking? Can I promulgate rules regarding swimming pools, regarding top lots, et cetera, et cetera? Chances are the answer is yes, you can. If you can't, it's because your documents are old and probably need to be updated. If that's the case, call me. I will do that for you. Do it all the time. So it's power you want to have as a board. And I know we run into these issues all the time with owners where I go to meetings, and a lot of my work involves writing amended and restated documents, where I take the existing documents and I basically do them all over again. I sit down with the board and I say, okay, what do you want to change? What are your problems? And they tell me, and then I write them a whole new set of documents. I show up at the meeting where the homeowners come, and sometimes there's a lot of yelling and screaming. And a lot of the yelling and screaming stems from the fact that there's a feeling among the owners that the board is trying to grab power. And I try.
Really?
And in answer to that, I say a couple things. One, you wouldn't say that if you were sitting on their side of the table, number one. Number two, it's not a power grab, it's to make the association more efficient to operate and to bring it into the 21st century and to address things that maybe the documents never, the drafter never contemplated. I mean, if your documents were written in 1974, there's a lot of things they didn't think about. Okay? So what I'm trying to say is just because the board has the power to do something doesn't mean it will do it. And even if it does, there are processes in place where there are checks and balances on that. Okay? And that's where we get to, you know, in the statute, in the Condo Act, and the Condo Act is much better at this than the HOA Act. The HOA Act doesn't have anything. And I personally am in favor of, you know, moving some of these statutes over, but that hasn't happened yet. The Condo Act has two provisions. One is 11.111, which controls how rules get adopted, and 11.113, which controls how they're enforced. In an HOA, usually those kind of provisions are in your governing documents, okay? Or they should be. What they say is that there's due process involved, basically. 11.111 says if the board wants to adopt a rule, and it has the authority to adopt it, it has to send it out to the community. It has to notify them when it's going to be discussed and give the owners an opportunity to appear at that open meeting and give their comments as to why they think it's good or bad. And even if it is adopted by the board, there's an ability for the owners to override the board decision by petition and have the bill and have the rule revoked or rescinded. Or owners can request specific exceptions in unusual circumstances from the application of the rule. Okay? So there is due process, and so what I tell boards is even if you guys have the power, there's these procedures out there which say that if they try and do something, they're still answerable to you. And at the end of the day, you vote for them. So if you don't like what they're doing, you vote them out of office. A lot of us might say, you know, go ahead and vote me out of office. But you know, this is such an honor that I want to continue. Next, distinguishing between rules and policies. Under the HOA Act, there's a provision that says that a rule is in order for a rule to be enforceable against the owners, it must be recorded in what they call the HOA depository. The depository is a place that's maintained by the clerk of the circuit court in the county where you are that maintains a file for every HOA, and they record copies of your rules. They stamp them, they put them in the file. It's an alternative to land records because land records will not accept these documents. They're not instruments, okay? However, they are enforceable. So the legislature said, well, in order for people to be on what we call record notice that these things exist, and in order for us to require them to put copies of them in their resale package, we have to have a place for them to be. So we created the depository. And the depository is not a big deal. You pay $5 per page, I think, up to a total of $25, no more, and it's in there, and it's enforceable. The question is, does it have, my computer again, does it have to be does it have to be enforced at all? And the answer is maybe. So, what I say is, if the resolution that the board is adopting is a restatement of authority that's already in the documents, like a collection policy, which merely says, this is the process we're going to follow to collect your money. It doesn't make any new provisions that aren't already in your bylaws. It does not need to be reported in the depository. Now, that doesn't mean you shouldn't send it out to everybody. You should, because then you're putting them all on notice that it exists, of the policy you're going to follow, and it gives them an idea of what expectations they should have about how the board is going to do this, and it encourages compliance, in my opinion. But it doesn't have to be reported. Condo rules don't have to be recorded anywhere. Okay? There's no recordation requirement for them, but don't forget, under 11.111, they were already sent out to everybody before they were adopted, and then when they were adopted, they were sent out again in final form. So everybody got it. Okay? So everybody's on notice that they exist. Yes, sir.
Short question.
Sure.
How would an individual homeowner gain access to the contents of the depository?
You can go down to the court and ask. Public record. They're all public records. In fact, some of them are online. Not universally, but some of the counties have put the depository stuff in the same computer index, electronic index, as the land records. So when you pull up the land records index, interspersed in there, you'll see depository documents that have been scanned. Not all the counties are up to speed on that, but some of them are. Okay, next thing. With regard to, and I'm going to skip down one and go back. With regard to architectural control, what you usually adopt in those circumstances are what we call architectural guidelines. Okay, and the question is, do you need them? And my answer is yes. One of the most common complaints I hear from individual owners is, I didn't know, fill in the blank. I didn't know. Because now if you say to them, well, were you at the meeting when such and such occurred? They're going to say no. Did you read the newsletter? No. But I didn't know. So my answer to that is, when it comes to architectural control, which is always a big issue because people have now spent money to do something to their property, and they don't like it when you tell them that what they spent money on now has to be undone because they didn't ask for permission like they were supposed to. So my answer is, well, did you have architectural guidelines? Did you give them an idea in advance what would be approved and what wouldn't be approved? Did you use those guidelines to remind them yet again that they need to ask for approval? Because people usually have to be beat over the head with these documents and told repeatedly, ask, ask, ask. So I say, adopt the guidelines. And what the guidelines will do will be twofold. One, they will set up a set of expectations as to what the community deems acceptable for what we can call its aesthetic standards. In other words, what kind of doors, what kind of frames, what kind of storm doors, what kind of garage doors, what kind of mailboxes, how high should the grass be, how high can the tree be before you can cut it down yourself, fences, pools, things like that. Governs all sorts of those kind of issues, and it gives people a set of expectations. The other thing it can do is, you can create in your guidelines a procedure where you can say to the owners, if you do this, this, and this, and you follow these guidelines, you don't need to ask for prior approval. Like my community, in the guidelines it says, if you replace your mailbox with one of these 3 mailboxes, you don't have to ask for prior approval. And as long as you've complied, it takes out an entire administrative process and relieves the board or the architectural committee of that burden. Because a lot of things you just don't need to sign off on. If they're replacing like for like, you don't care. You don't want to know about that. It's only the ones that are trying to do something different that you want to hear about. Okay? All right, so now we go back into enforcement. First thing, and I'm skipping again a little, I'm going to go back to uniformity and consistency. Why inspections? Why inspections? Okay, when it comes to architectural control, a couple things. You want inspections because you want the owners to know that the board is on top of what's going on. Okay? You don't want anybody to get the impression that the board doesn't care, or is lax, or is asleep, or what have you. So whether you use the management company to conduct these inspections, which many associations do, and they will do that for you, or you as board members volunteer to do the inspections, or you have a committee to do them, they should be done, I'm going to say at least once a year. At least. Many communities do it more than that. But at least once a year, so that you are on top of what's going on. Because, here's the kicker, if an architectural violation in general has been in place and present for 3 years, you're going to have a really hard time getting rid of it. And the reason is that when you talk about violations, what you would be asking for a court to do, if you had to go to court to get rid of it, is to tell the owner to take it out or to get rid of it, okay? And when a court does something, when it tells somebody to do something, it's sitting as a court of equity. And Maryland circuit courts are either courts of law or courts of equity, and they function as both, okay? When it's sitting as a court of law, it's empowered to enter judgments for money. When it's sitting as a court of equity, it's empowered to tell people to do things, and it uses injunctions to do that. If you ask for an injunction, and you're asking to remove a violation that is in general more than 3 years old, the defendant, if they have half a brain, or their attorney does, is going to claim a defense called latches. And latches is an old-fashioned word that is basically the equitable equivalent of a statute of limitations. Now, court judges have a little bit of leeway in equity, okay, because it's not law, so they have a little bit of wiggle room. But in general, they're going to borrow the limitations period from the law and apply it to equity. And they're going to say 3 years is pretty much my magic number. If it's been there for 3 years and you guys haven't done anything about it, guess what? You're out. I'm not going to make them take it out. There's other considerations, like what's the relative burden? For example, is the burden greater on the owner for having to take out the pool that he put in without approval? Or is the burden on the association greater for having to suffer that violation continuing? And I'll be honest with you, most judges will say that the burden on the owner is greater, and they'll side with the owner because they're looking at money. And the danger to the association for having to suffer that violation is intangible. In other words, we can't really quantify it. We can't say it's worth X dollars because we don't know what it's worth, but we do know it has an impact. Because the more violations there are, the greater chance that that a court is going to say on the next violation case, the next swimming pool, well, you guys have abandoned the covenant because you didn't enforce it over there, and you couldn't enforce it over there, so you can't enforce it at all. It's completely out the window. So that's why you have to beware of, the uniformity and consistency. That's the most important thing. Okay? Enforce your rules and regulations and your architectural covenants in a uniform and consistent fashion, which means you do the same thing with respect to every similar violation. And if you're going to impose a fine, you better make sure the fine is comparable across the board, or the owner is going to say, I am the victim of selective enforcement. When my neighbor put in his pool, you didn't make him take it out. Now you're making me take it out. That's selective enforcement. I shouldn't be required to do that. When he, didn't pick up his dog poop, you didn't fine him $50, you just fined me $50. That's selective enforcement. It's also not uniform and consistent. The board has to maintain uniformity and consistency. And it's very important, especially in community associations, because you have board members going on and off. So you want to create what we call an institutional memory. In other words, document these things. And a lot of associations will adopt fining policies, and they'll say, okay, the fine for this is this, the fine for this is this, the fine for this is that. And you don't have to, but it's helpful. Because when you have board turnover, you're not relying upon one board member that's been there for 4 years to remember, well, 3 years ago when we had this violation, what did we do? And if you don't have the minutes right there in front of you, you don't know what to do. But if you have a policy that says, every person that fails to pick up their dog poop gets fined $25, it's a no-brainer. That's what they get fined. The important thing, the next important thing on enforcement is follow the procedure. In a condo, 11-113 of the Condo Act says, you give them the first notice, and they have an opportunity to cure without further penalty. If they don't do it, or they commit the same violation in the 12-month period, you send them another notice and says, guess what? Now you're going to come to a hearing. You hold the hearing, they have the opportunity to come to the hearing, and they say they have the opportunity to present evidence on their own behalf, give you their story, then the board makes its decision. It either says you have to remove the violation, you're fined X dollars. If it's a continuing violation, you say you're fined X dollars plus Y dollars for every day it goes on without abatement. Or in some cases, you can say the association's decided it's going to exercise self-help. If you don't cut your lawn, for example, within a week, we're going to cut it and charge you. Now, the board can do that even without holding a hearing. You can exercise self-help without holding a hearing. Although, I wouldn't recommend it. If you have the time to go through the process, my default rule is go through the process. The exception to that would be towing. Where you are permitted to tow, obviously the timeline of towing does not match up with the timeline of due process. However, the towing procedures in most counties require signage. So that gives you the due process stamp. In other words, the sign's already there. It says if you park here and you're unauthorized, you'll be towed. And this is what's going to happen to you. So you at least have, there's notice. So I don't worry so much about that. Yes?
Since a lot of people don't like violation notices, is it okay to put out like a friendly reminder a few months before or a couple months before a violation notice?
Yes.
Like
as long as you're doing that consistently.
consistently.
As long as you're doing it consistently.
And if you miss that 3-year statute of limitations, could you put a requirement in that any time the house is sold, that it be brought back to standard?
You can try. It's not enforceable necessarily. Now, if they comply voluntarily, that's fine. And I'll get to that in a second in terms of getting these resolved. Yes?
No, one of the complications in this, and it comes back to the I didn't know, is that the unit is rented.
Right.
The renter doesn't get a copy of the guidelines, puts up a fire red curtain in his window, which in our community is forbidden.
Right.
And then you have a problem of communicating with owner maybe 2 states down the line here, and it makes it very complicated.
Well, here's how I recommend that people deal with rentals. Where you have rentals in the community, I recommend that the board adopt what we call a lease addendum resolution. And what it'll say is that every time the owner rents his unit, is required to use this lease addendum. What the lease addendum will say is that the tenant agrees and has to sign the addendum, agrees to be bound by the covenants, rules, and regulations of the community, agrees to be responsible for violations of those rules and regulations and covenants, and agrees that the association can evict them if the owner does not, and agrees that if the owner fails to pay, the association can notify the tenant of the delinquency and garnish the rent without first obtaining a judgment. If everybody signs that, the association, the tenant, and the landlord, then it constitutes a contract. And it binds the tenant to the association where it previously has no contractual connection whatsoever with the tenant. Okay? So it makes the association able to go after the tenant as well as the landlord. And it also will provide that the landlord is required to provide the tenant with a copy of all the governing documents when the tenant moves in. It helps. It's not foolproof, but it helps. Yes, ma'am.
So, in terms of consistency, So you missed the pool and somebody else wants to do a pool and the board realizes, okay, we can't fix that pool. But we don't want another one.
Right.
So is it okay to say, to kind of just do a mea culpa and say, look, we realize that this particular owner was in violation, we can't enforce this, but heads up, don't you try it because we'll enforce it. Can you do some kind of
Yeah, I mean, well, here's the thing. There's no bright line rule for what constitutes abandonment. In other words, is it 3 violations out of 100 lots? Is it 5 out of 50 lots? There's no way to know because it's dependent upon the judgment of a judge. The judge will look at it and say, you know, my gut is that this is too many and I think you've abandoned. What I say is that the association does not have to be perfect. In other words, I would not decline to enforce that second violation just because the first one you might have missed it. And I would still send a notice of violation to the first owner with the hope that you might be able to obtain voluntary compliance. And here's where we get to ways we can resolve these things. Keeps skipping on me, sorry. In terms of enforcement, okay, there's a couple different lines of defense. The police and the local governments are good for some things, like noise violations. For example, police are really good for noise violations. Local government is good for zoning violations. Like there's too many people living in the unit, okay? And that one, that too many people, is really difficult because under federal constitutional law, the way the term single family is defined and interpreted, it basically opens the door to anybody who can be considered the same household. However, there are still overall occupancy limitations that the zoning ordinance imposes. The association isn't well suited to pursue those kind of violations because you're coming at it from a single family perspective. In other words, that's the covenant you're trying to enforce. You don't usually have in your documents occupancy limitations. I haven't seen it, but the county does. So you go to the county and you say, we understand this might be a single family. However, there's 27 people in the family living in this townhouse. What can you do about it? And the answer is they can do something about it. Because not only is it creating overcrowding, it's creating garbage problems, it's creating noise problems and traffic and parking problems. So they can help you there. Next level of defense is fines, okay? Fines are good for some things, like you forgot to put your trash can back in, you didn't pick up after your dog, things like that, okay? You left your Christmas lights out too long, whatever it is. But not good for some other things, like cutting lawns, okay? In most cases, if somebody doesn't cut their lawn after being notified, it is cheaper and faster for the association to send a notice that says, if you don't cut your lawn within 3 days, we're going to cut it and you're going to be charged. And then cut it and it's done. Why have a hearing about that? Is there any debate as to why the law? I mean, there's no debate why the grass is that high. It is what it is. And it's an easy resolution. The next is litigation, okay? If you get to the point where you can't resolve it any other way and everybody's dug in their heels and there's no other way to go, there's no way to get rid of that shed except to file a suit, then you may be forced to file a suit. It's a last defense, a last avenue of enforcement that I would recommend. It's very expensive. The cheapest covenant enforcement case could cost the association $20,000 before you blink, okay? Litigation is expensive, it's time consuming, and it's aggravating, okay? And it doesn't get you to a quick resolution. So what can you do to avoid it? That's where we get to settlements, okay? So going back to that lady's question about the pool that you missed, all right? So you get to the pool and the board's like, well, we're not sure. It might have been there 3 years, might have been there 5 years. We don't really know. We weren't doing inspections then. We're not sure how long it's been there. Well, you send the guy a violation notice and you see, or woman, and you find out what's their response. Do they respond? Hopefully they do. They come back and they say, okay, You know, it's been, well, it was there for 5 years, and yeah, I forgot to apply, but, you know, it's been there so long, and all the neighborhood kids swim in it, and everybody's happy, and what's the problem? So the answer is, okay, the first question is it a violation? Is the pool something that you could have approved if it had been requested in a timely manner? And if the answer is yes, then that's an easy resolution. You just have them submit a retroactive application, you approve it, you document it, and you're done. If it's something that couldn't have been approved, then you say, okay, we didn't have the authority to approve this, so we have two ways we can go. Either you, homeowner, can try to change the documents to permit this, you know, where swimming pool, in-ground pools are prohibited, you can try to get the owners to agree to permit them. You know, we as a board won't necessarily take a position as a board. We might vote one way or the other as individual owners, but we won't take a formal position. If you want to try and do that, that's fine. If they say, no, I don't want to do that, what else is there? Well, what if we agree that the pool stays until you move? Okay, so you write up an agreement between the association and the owner that says, when this property is sold, the pool will be removed or filled in or whatever they do. And you sign it and you record it. So now it's of record. Anybody that searches the title on that property will know about it. There won't be any question about notice. It'll be reported in the resale certificate that the agreement exists, and there'll be provisions in the agreement that if the homeowner fails to do it, that the association will do the work and the homeowner will be responsible.
Is that better than putting a lien on?
Well, yes, it is. Well, because here's the thing with liens, okay? In order to put a lien upon an individual property, you have to follow what they call the Maryland Contract Lien Act. So there has to be a contractual basis for the lien. So what does the lien secure? It either secures the payment of assessments that are unpaid, or it could secure fines. Okay, so if fines have built up on the property, you could secure the payment of the fines for the lien. However, Maryland law now prohibits you from foreclosing on a lien that includes fines. So although it is good for resale purposes or refinance purposes, it cannot be foreclosed upon. So there are limits. So I would say that the value of the lien is limited for that reason, that it's not ultimately enforceable in the way that you want. Yes, sir?
One question. We have a restriction on dog size.
On what?
Dog size.
Dog size, got it.
We have a violator, and someone, and he's running back to medical, doctor shows that he
Therapy dog?
Yes.
Okay, I'll get to that. All right, here's the deal.
He accepted that.
Right, here's the deal.
Does that put that put the board at risk?
No, because you couldn't have prohibited it. In other words, as you all may know, there is now a cottage industry out there of therapists that will certify that your pet is a therapy animal. It is necessary for you to use and enjoy your property to the fullest potential because you're depressed or whatever. I mean, not to minimize actual need for therapy animals. It is out there. I understand it. I recognize it. I tell all of my clients to abide by it and to honor it.
So you got a smaller one.
Because it's simpler not to. Well, because my ideal scenario always was, what happens when the therapy dog is a pit bull?
Yes.
Okay, and my answer was, doesn't have to be that dog. So, under the Fair Housing Act, you are required to make what they call a reasonable accommodation for therapy animals, because they are necessary to enjoy equal housing opportunity. And although there's no strict bright line test as to what documentation may be necessary, the law says that if disability is obvious, you can't ask what it is. If it's not obvious, the association has the right to request documentation, but my practice has been if the documentation from the physician establishes a connection between the disability, the ability to enjoy the dwelling, and the animal expressly, I say that's enough to require the association to waive its otherwise no pet rule, for example, to permit the pet. However, there are rules and regulations that you can impose on the manner in which the pet uses the property. In other words, you can require them to use service elevators. You can require them to pick up weights. You can require them to be leashed or carried. You can limit size. So there are reasonable restrictions that can be imposed upon therapy animals, but you have to be really, really careful about that. Yes?
That violation is acceptable. In the circumstances we all understand.
The reason it's acceptable, I'll tell you why, is because a therapy animal is not a dog.
No, he was
Or
a
cat.
veteran, he came out from overseas.
Right.
We know circumstances, we accept it.
Right.
But that can put the board in hot seat for other issue will pop up later.
In terms of what?
There are other people can bring, like you say, it's a thing to say.
Well, unfortunately, that's unavoidable. And I've seen such a proliferation of therapy animal requests recently that I can tell you that that is the way of the future. You're going to see them. And the associations would be hard pressed to deny them if the documentation, basically passes muster on its face. I tell them to permit it because it's not worth, because the odds are the association would be unlucky enough to pick the one case where the person has a solid case, and that's the one where they chose to take a stand, and they'll get hit big time with damages, big time. So I say no, just don't even bother. It's not worth it. And the problem is that while you don't have a lot of discretion on therapy animals, they don't constitute, a therapy dog is not a dog. Okay, so for example, if you have a pet limitation that says 2 pets, then somebody can have 2 pets plus a therapy dog. Right, because that dog is not counted as a dog for purposes of a limitation on the number of pets. It's the way the law is. You can't do anything about it. Yes, did you have a question?
We had a case where during the building of our community, the developer had control of the architectural committee.
Right.
And the developer allowed one of the owners to build a patio that extended out into the common area.
Right.
Now, 8 years later, one of the other owners decides they want to build a patio, and they wanted to get the architectural committee, which we now control,
right,
to agree to allow them to go out into the common area.
We said no.
We said no.
Right. That's fine.
That would be fine.
Yes, because the prior one was permitted erroneously. And what I would suggest you do actually on the prior one is to get the homeowner and the board to agree that there's an encroachment and that it's that it's being permitted. Because then you won't have an adverse possession problem later. Anybody else have questions before we? Yes, ma'am.
When a rule is unenforceable because it hasn't been enforced,
what can you do?
Remedy, or what would be the way that could be ameliorated?
If a rule is not enforceable because it hasn't been enforced, you make a new rule. And it's enforceable from that point forward. However, you can't necessarily do anything about the violations that exist. You may have to wait until they cycle out of the community naturally. Because you're not going to be able to be retroactive in the enforcement
It
process.
sounds like you need to be more, much more specific than your general rule might be.
Possibly, yes. Yes. Or just more vigilant in the enforcement. Yeah.
This question is a little off the subject, but it is about documents. I was reading an article in Common Ground, which,
yes,
as you know, is the CAI
yes.
monthly publication.
Right.
And it talked about the dangers of having things like the declaration and the bylaws expire.
Right.
What's the situation in Maryland with respect to those things expiring?
Well, okay. First thing is, the bylaws cannot expire unless there are terms in them originally that set some expiration date, which is, I've seen but is unusual. Most of the time they say they're good for 20 years and will renew, for example, for successive 10-year periods. That's more typical. I have seen some sunset provisions. They're very rare, but if you have one, I would suggest that you amend your documents to take it out and put in a perpetual duration provision. With regard to the bylaws, if you're a corporation, an incorporated homeowners association, they can't terminate because the association's existence is perpetual by default under law. So a corporation, once it's created, unless it's allowed to lapse, will go on forever, as will its bylaws. Anybody else? Yes, ma'am.
I just had a question about the violations concerning maintenance violations. Are
Okay.
those subjected to the 3-year? I mean, we have a unit that's deteriorating and you can't.
Generally speaking, yes, they are. So if you have a maintenance violation that is more than 3 years old, my recommendation would be to exercise self-help. Because you're not prohibited from solving it yourself. You might have a problem, however, requiring the owner to do it, and you may have a problem collecting the money that you spend to cure it yourself, i.e. the association. But if the violation's been resolved, then that solves the majority of the problem.
So rather than litigation with this?
If it's a violation that can be cured
Won't they call
easily.
the police and, do we have to get police? I mean, this guy's crazy. He just wanted on his property.
If you have a situation where you believe that the association or its personnel might be in danger, then my recommendation would be to get an injunction first. But if it's more than 3 years old, it's going to be difficult to prevail. However,
I
that
thought they
being
would
said,
have more sympathy.
that being said, the very fact of filing the litigation could put you in a posture where you can settle with the owner. In other words, if the owner is faced with all this expense defending themselves versus allowing you to correct the violation. I mean, at that point, the association's better served to spend its money to fix it than it is to spend money litigating it. So even if you had to eat the money on the repair, you're better off than fighting about it. So, I mean, for example, I have a situation like that now where we have a townhouse association that's got a non-compliant roof. It's within the time period, but the wrinkle is that there may have been a conversation between the owner and a member of the ACC where the ACC member may have verbally said that the roof that he picked was okay. And there's apparent authority issues there. In other words, did he speak for the ACC? Did he not? Could the owner have relied upon this or not? There's enough question there that it's not worth litigating over. So the resolution is, the association said, we'll replace the roof at our expense. But now we have uniformity, because the roof is a completely different color than everybody else's roof.
And then they don't charge
it's
the owner?
obvious.
They don't charge the owner?
They're not going to in this
When they
case,
comply?
because it was the association's fault indirectly that this problem came up. So now they've been chastened by me for speaking. So I said to the ACC member, don't do that again, because when you talk to them, off the record, and they rely upon it to their detriment, arguably, you're creating a situation where you make enforcement complicated, if not impossible.
So also when we go to apply a lien to a home, do you now recommend that we take out the fee portion of it?
The fine.
The fining portion
Yeah,
of it?
what we've done is, in our office, what we've done is we've split the lien. So in other words, if the management company tells us that there's a lien, that an account that includes fines, and late, there's other things that are excluded as well by the Contract Lien Act. If it's anything that the Contract Lien Act doesn't allow you to foreclose on, we will send a notice for everything, but then we'll record 2 statements of lien for the same period. One will include everything, and one will include only the amounts that can be foreclosed on.
Okay. All right.
But we would only do that if the association said that there was a likelihood that they might foreclose. Otherwise, it's not
We're in
worth
that
spending the
situation
extra money.
too, so.
Right.
Okay, yeah.
Anybody else? Question? Yes, ma'am.
What about issues with foreclosed properties where the bank refuses to file with SStat that they actually now own the property and there's serious maintenance violations? And so, they're not filing with SStat because they don't want to be on record and they don't want to have to pay the HOA fee. So what kind of recourse do we have with that? We have townhouses that have holes in them and really serious deterioration.
If the association's in the position where it can spend the money to correct it itself and then charge it back, my recommendation would be to get from the foreclosure attorney the contact information for the lender that foreclosed, to send them notice of the violations and notice that if they don't cure them, the association will exercise self-help at their expense. Then do so, add it to the account, it will be on the resale certificate that they will have to require when they ultimately flip the property, and then you'll get paid. With the assessments, most likely, because they're probably not paying those either.
No. Yeah, okay, thank you.
Yeah, because they play catch-up. Anybody else? Question? Yes, ma'am, I'm sorry. Okay, going on to meetings, very quickly. Sorry. Couple of different kinds of meetings. There's owners' meetings, council of unit owners, association versus board meetings. Documents provide for both. Annual meetings, where you usually conduct your elections, and special meetings, which are conducted for specific purposes, such as special assessments. Every meeting in Maryland is deemed by default to be open, okay, except where the statute and both the Condo Act and the HOA Act provide specific circumstances when you can close a meeting. Do not close a meeting unless you meet those criteria, because if you do something in secret, you're going to get dinged for it. And the Attorney General is the one that's going to ding you. Because what will happen is the homeowner will write letters of complaint to the Attorney General, and then the Attorney General will write you letters and say you have violated the Open Meetings Act, and then you'll have to do it over again. And it just becomes a big headache. Also, there's some argument that if you've made a decision in secret that should have been made in the open, that the owner could challenge the decision as being applicable to them, and then you'd have to do that over again. So you don't want to be in that position. Whenever you have a meeting, you are required to have an owner forum section. There is a split of thinking as to when during the meeting this should occur. On one hand, if you put it at the beginning, you can cut them off easier because you have the rest of the meeting you have to do. You just cut them off and move on. However, that doesn't always work. You are allowed to put time limits on owners who want to speak about specific issues, as long as everybody's subject to the same limitation. Okay? Everyone's treated the same. You can put the open forum at the end, but then you risk being there all night.
If you have no one there,
you don't have to have it.
you don't have to have it, it should be.
It should be on the agenda.
Minutes.
Should be on the agenda, and the minutes should reflect that nobody
there
was
was
present,
such a
that
thing.
nobody was present to exercise their right to speak up. Yes, sir.
We do go to closed meeting when we're going to delinquent reports.
There is an argument to support that, although it's not, it is expressly stated in one place. I would on balance, I would agree with that because the flip side is, there's more liability on the flip side. Practically speaking, yes.
What's the difference between a closed meeting and a working session?
There is no such thing as a working session. Every time that the board gets together and there's a quorum, there is a meeting. Okay? That being said, we all know, managers and attorneys alike, that boards are having working sessions. And what we say is that you're not supposed to have them. You're supposed to be meeting in the open or closed if permitted.
Does that also include a hearing, like a violation?
Hearings are different, they're not meetings.
Oh.
Yeah, you're not conducting association business in the same, you're sitting not as a board making association decisions, you're sitting for adjudicatory purposes. So I say it's not strictly speaking a meeting, yes.
Okay, at the owner meetings, you have to have a quorum, right, in order to?
You have to have a quorum at all meetings.
At all meetings?
At all meetings.
Okay, and?
Which can be satisfied by proxy or in person.
Okay, and?
Except board members can't have proxies for board meetings.
Okay, and that's already stipulated in your documentation?
That's correct. Yes, ma'am.
Could a board member attend the meeting by Skyping?
Yes, as long as everybody can hear everybody all the time. Yes. Also by telephone, conference call. I have board members that speak by conference call. That is possible. And that the owners can participate also. In other words, there has to be a mechanism for everybody eligible to participate. Yes.
So all of these terms and rules, are they defined somewhere that say, you know, so me, I'm just a community member, I don't really know anything. I know I get voted onto the board, how do I know?
Yes.
All the.
There are. I will tell you that all meetings have to be open unless they're permitted to be closed. And after we're done, when I come up, I will point to you in the statute where it says the reasons that you can close the meeting without having to go through them.
I'm going to add to that. That also applies to committees, am I correct?
Yes, you are 100% correct. Any association meeting, including committees. Committee meetings are also subject to the open meeting. And arguably less likely to be entitled to close their meetings than a board would be. Although I could see there might be circumstances where a committee might be able to close a meeting, like if you set up a litigation committee and they were meeting with the legal counsel, you could close the litigation committee meeting for that reason.
And anytime you have a meeting, then you have to notify all owners.
Yes.
When the meeting is being.
That's correct. And it is permissible, if the board can agree upon a schedule of meetings for the year, to give one meeting notice at the beginning of the year, it just suffices for the entire schedule, so long as it's not varied. So if you do vary it, then you have to give them notice that it's been changed. Yes, sir.
Just some clarification for us. We have I'm sure there are a lot of boards in the same way, but our community members aren't that interested in coming to meetings, ever. So it's almost always just the board, maybe one other person. So generally in the past, we have opened the meeting, and when there wasn't a quorum present under the board, we close it for 15 minutes, open it back up, and then we establish a quorum. I just wanted your take on operating in that manner.
Oh, wait, you didn't have a quorum of what? The owners? For the homeowner meeting, you mean?
Correct.
Okay, and your condo or HOA?
Condo, yeah.
Okay, there's a provision in the Act which allows you, as you know, to suspend and reconvene as long as you meet the requirements in the statute about notice. In other words, it has to be in the original notice that you have the authority to do that. If it is and you've complied with the statute, then you can do it.
Can you direct that to the same thing for homeowners, not condos?
It's in 5B206 of the corporations article, and it's in the book. I can show you.
But the same thing?
Yes, same thing. Yeah. That provision of the corporations article has been put into the condo. They lifted that language and they put it in a section of the condo. So now it applies to both kinds of associations. It gives you the ability, if you don't reach a quorum and and it's in your original notice that you can reconvene, then you can do that subsequently, and then whoever appears is the quorum. For board, that only applies to owner meetings. For board meetings, it's a majority of the board. Yes?
For the owner forum, is it best just to say you've got 5 minutes?
Yes.
And then, or whatever time you deem.
That's what I would recommend, or less.
You've got.
My experience, they can say what they want to say in 3 minutes.
Okay.
Can you put time on your agenda?
You can have a timed agenda. I have communities, I mean, it's not legally required, but if it's helpful to you, you can time the agenda and put it right on the agenda.
Can the board meet without a quorum?
What's that?
Can the board meet without a quorum?
Without a quorum
Right.
of the board?
Yes.
No. What's not a board meeting then?
Because they're not gonna do any voting, they're just discussing issues.
Well, then it's not a meeting. It's not a meeting. Anytime you have a quorum present, you're at your meeting. So if you have 5 members of the board and 3 of them are standing in the parking lot, guess what? You're meeting. Don't make any decisions. Oh, Robert's rules. I'm sorry.
That's okay.
Robert's rules, sorry. Many communities use Robert's Rules of Order. And it's something that, I'll tell you, it's not legally, there's no legal requirement to use them unless your documents specifically prescribe it. I have seen that in places, but it can be cumbersome because not everybody really knows how to follow them. My general watchwords are be respectful, everybody gets a fair hearing, and make sure that you're spending an adequate amount of time on the issue that you feel as though both sides of the question have been fully explored.
Decorum.
Basically, yes, decorum.
Because it can be cumbersome, it is.
It's very cumbersome, yes. Yeah, strictly following them, which most people don't really know how to do, can be very cumbersome. Any other questions on meetings? Okay. Moving on, we talked about a little bit of the Fair Housing Act, reasonable accommodations versus modifications. An accommodation, thank you very much. An accommodation is where you're required to do something or not do something. A modification is where the property itself is changed. So for example, accommodation, allowing the therapy animal where your documents would otherwise prohibit pets. Allowing a deaf interpreter at a meeting. Reasonable modification, handicap ramp. Easiest one, okay? Reasonable accommodations are provided at the expense of the association. Reasonable modifications are provided at the expense of the owner requesting. The association may require a modification to be removed if it is made to the common elements, if the need is no longer present for it. So for example, somebody moves into the community, needs a handicap ramp, if that person moves out, you can require the ramp be removed at their expense. Yes?
Not a particular house, but in our neighborhood, we have a particular corner. Our neighborhood is over 30 years old. A tree has come under the sidewalk and messed up the sidewalk. There's a corner where a school bus comes to and the junior high kids meet there and whatever. I walked over there the other day and almost hurt my ankle. Is it the homeowner? Is it the county who's supposed to fix it? I doubt if it's the association.
Whose sidewalk is it?
The county, it's on the county right away.
Okay. Who shovels the snow off the sidewalk?
Homeowner's supposed to, by county ordinance.
The homeowner is supposed to. Well, then the homeowner is supposed to fix the buckled sidewalk because the owner of the tree is not responsible for the natural growth of the roots. Roots go where they go. Roots go where they go. So if the root uproots the sidewalk, it is responsibility of the owner of the sidewalk to fix.
Answer I wanted to hear.
Take a look at the plat.
Yeah.
Plat for the unit, for the house, the lot.
And where the lot line
And
is.
see where the lot lines are. Yeah. Because that sidewalk may be in the county right away, maybe.
Or it could be association common
It could be
area.
association common area, it could be unit on the, it could be the county.
Yes.
If we, being an older association, our documents were adopted in '79.
Yeah.
If we went to sit down and just with you and go over, how much would that cost? We don't have a whole lot of money, but I mean, is there an hourly fee or?
No, I would do it as a package. We'll talk about it. Call me and we'll talk about it. It depends upon what your documents are now, how big the association is and things like that. I mean, you know, because I wouldn't, you know, if you're if you're 50 homes, it's not going to cost the same as a 500 home association that's part of a structure with like where it's a sub-association of 3 associations, for example. I mean,
I'll call you.
Completely different thing, definitely. Anybody else? Any other questions? Okay, just to finish up, we already talked about hostile housing environment. Last thing, overlap with the Americans with Disabilities Act. The Americans with Disabilities Act only applies to areas of public accommodation. In other words, it does not apply to your swimming pool unless you sell outside memberships. People in the association are not the public. Okay? So if it's a closed set of people, including their guests, by the way, closed set of people, not public. If you sell to the outside, it could be public. If you rent your clubhouse to outside people, you could also be required to comply with the ADA. The ADA is usually enforced in terms of design criteria. So it's a question as to whether you would be required to retrofit something. Usually this comes up in the area of like handicap ramps and elevators and things like that. So just be aware as you're making decisions about your common areas, whether you're going to run into this particular area, the ADA universe. That's all. And you know, it's one of these fact-specific questions. So if you have questions about it, call your attorney, call me, please, and we'll talk about it. There you go. Thank you for your questions. I know I talked a lot. I hope you answered all your questions.